Hey friends, so this video is for you if you're one of those people and maybe you're standing around a group of friends or relatives and the topic of estate planning comes up and you're one of those people who says, I don't even have a will. This video is for you. So a beginner's guide to your first, last will and testament. I'm Paul Rabelais. Quick intro on me. I've been an estate planning lawyer longer than I care to remember, more than 3 decades. Started in Louisiana, and several years ago, started making these YouTube videos. They got kind of popular. And after hundreds of thousands of subscribers, and by the way, if you're not a subscriber, probably wouldn't hurt for you to subscribe. And but started getting requests from all over the country to help people get and keep their estate legal affairs in order. So we now have this national little boutique estate planning law firm called America's Estate Planning Lawyers. We help people around the country get and keep their estate legal affairs in order. There's a link in the description for those of you who want to know more, maybe even start a conversation. So I've divided this video into 11 components. And really, this is estate planning 101. It's last will and testament 101. Although I'm going to sprinkle in some really good nuggets here that even the people who know something about this topic, I think can benefit and learn from this live stream. So the 11 parts, and if you're watching a recording of this, you can follow along in the chapters that I'll make below. But if you're live, here's the 11. Number 1, understanding the purpose of a will. Number 2, inventorying your assets. Number 3, identifying your beneficiaries. 4, choose your executor. 5, guardians for minor children. Number 6, deaths and taxes. Number 7, fulfilling the legal requirements. Number 8, when to update things. Number 9, other estate planning tools. 10, seek professional advice. And 11, communicate your wishes. All right, so let's jump right in. By the way, a couple of rules that we have. I love doing these live streams because it enables people like you to contribute by adding to the chat. So feel free to add your, of course, positive, follow the community guidelines, constructive, positive, whether it's comments, questions, experiences that you want to share. Everybody benefits from those, so feel free to throw it in the chat. I'm going to go through my material, and then when I finish my material, I'll head over to the chat and we'll hit those as appropriate. Okay, let's jump in. Number 1, and by the way, maybe you'll just start the chat by giving a shout out as to what state you're in. Always like to see that. We get people from all over the country, sometimes in other countries, but feel free to throw in the chat your state and we'll keep rolling. Number 1, understanding the purpose of a will. And again, this is those people who I'm not even sure what a will is what you're saying, or, what is a will, or what's the difference between a will and a trust? So if you're in that ballpark, this is for you. So starting the basics, understanding the purpose of a will. And yeah, we'll talk about some more sophisticated planning techniques as we go through this, but it's understanding the purpose of a will. The main one is so that you can determine who gets your assets when you die. So a will is only effective when somebody dies. There's no provision in your will that's effective during your lifetime. It only takes effect when you pass away. So the main purpose of the will, and there are many purposes, but the main purpose is to specify who gets what you own when you die. Because if you don't have a will, then you live in a state like Paula lives in Texas, Candy lives in Alabama, like Rand Wolf in Colorado, Margaret from Connecticut. Your state has rules, and so the legislature, the lawmakers of your state have already written rules that were made many decades ago, probably been revised over the years, where they kind of guessed who should get your estate when you die. And so they put all of that into law. So if you don't have a will and you die owning some assets in your name, then that state law will apply and direct who inherits from you. And for many people, those state laws, they're called intestate laws, because you saw my first notice in the top chat was when a person dies without a will, and hopefully everybody on this live stream either they already have their will, or they're going to have a will in the future. And so everybody on this live stream at some point is going to be considered a testator. If you have a will, you're a testator. If someone dies without having a will, they are deemed to have died intestate, without a last will and testament. So hopefully we got a bunch of testators or testators to be. You've probably been called a lot of things in your life, probably never been called a testator. So I'll be the first. Okay, so yeah, one of the kind of the basic underlying premises of your will is who gets your stuff when you die. A lot more on that later. There's some other reasons people write wills in their, when you die, whether you have a will or not, somebody's got to be in charge of making sure that your stuff goes where you're supposed to go. Maybe you have a will that says, I leave my estate to my 4 children equally. Or maybe you have a will that says, I leave $10,000 to my church or to my college, and I leave my house to my daughter, I leave my business to my son, and I leave the rest of what I have to my children equally. Well, every estate that gets settled, maybe I shouldn't say every, maybe I should say like 99%, but let's just say every for now. Every estate that gets settled, somebody's got to be in charge of making sure that everything goes where it's supposed to go, making sure things like if you have any outstanding bills or credit card bills or car loans or a final income tax return needs to be prepared for you. Every estate that gets settled has to have somebody in charge of settling that estate, making sure all that stuff gets resolved, and then making sure everyone gets what they're supposed to get. So typically, when you write a will, that person that you designate to do that is called your executor. We'll get to that in a minute as well, as to some of the intricacies of designating the right executor or co-executors. But I'd say that's probably the second reason people write wills. Number one, determine who gets your stuff. And number two, designate your executor. Maybe number three is if you have minor children. A lot of the people that we write wills for, they don't have minor children because it seems like people get serious with us when they're in their 50s and 60s and 70s, when they know they're not getting any younger and they want to get serious about getting this right. That seems to be when they contact us, and they don't have minor children. But there's really no better reason than to write a will if you do have minor children, because in that will you can designate, okay, if the parents pass away before the children reach the age of majority, the parents have the right to designate who they want to be those backup parents or guardians of the children. Who has the right to raise the children, determine where they live, where they go to school, what medicines they take? Who's going to be those backup parents for those minor children? And so for parents with minor children, writing that will and designating that guardian for the children is one of those really important reasons why people write wills, especially people with minor children. Okay, so we're going to hit on so many more issues, but those are the three main issues. Designate who gets your stuff, and there's a lot to that. Designating your executor or executors, and then designating guardians of minor children if you have minor children. All right, so that's number one. Number two, we need to talk about how you should inventory your assets. And by the way, we got Linda from Wisconsin. We're covering the whole map. We got News Johnson from Texas. I've got 2 people from Texas so far. If one has a trust, do they need a will? I'm going to get to that, News Johnson. So good question. I'll get to that maybe around number 10 or 11 as we get into other planning options that you have. But a little quick story here, not even a story, a quick answer. The answer is yes. Okay, for reasons I'll explain later. All right, so number 2 is inventorying your assets. It's not really the reason people write wills, but it's just a component of the will writing and estate planning process. It helps you when you have a good inventory of everything you own. It helps me when I'm helping people structure their estate to have a good inventory of what they own. Most people these days, when they get around to writing their will, most people, and not everybody, but most people, they own a home. They probably have some retirement accounts, 1 or more. They've got some bank accounts. They've got some vehicles. And then they'll have other assets, maybe rental property, maybe a business, LLC, maybe a Roth IRA, maybe boats, motors, trailers, who knows, any number of things. There's so many types of assets that people have, but it helps when you are writing that first will to have an inventory of your assets in place, so that both you and the perhaps professional who's helping you through that can understand what you own, and then can make the necessary provisions based on any kind of unique circumstances or unique assets that you may own. Now, in addition to not only what you own, because when I talk to people the first time and often on Zoom calls with people around the country, I'll say, give me an idea of what you own. And they'll say, well, we own our house and it's worth this. And maybe they'll say still have a mortgage on it. Maybe they'll say it's paid for. They'll talk about all those things that we have. And I'm also like, well, give me an idea, give me a ballpark idea of the value of all of these things. Well, our house is worth about $800,000. And then husband and wife may argue, no, Maple down the street sold hers for 650, and so I don't know if it's worth 800,000. Yeah, but they had a pool, and then this person next down the street sold theirs for 950. Yeah, but they had fresh paint on their house. So anyway, people get into way too much, more than I need to hear, but it's fun to watch them talk about the value, especially the subjective value of certain things that they own. So people go through and not only make that inventory of assets, but make that kind of determination of approximate fair market value. I don't need to know, for example, exactly whether your house is worth $800,000 or $850,000 or $600,000. I need to have for starters, I need to have a general idea of the total value of everything that you own, because that could have some federal estate tax consequences. And depending upon what state you live, it could have some state estate or inheritance tax consequences. We'll get all that stuff when we hit taxes in a minute, but that's why it's important to have an inventory of the assets and an estimation of the fair market value of those assets, so that we can address any potential tax savings mechanisms that we may need to make, like gifting before you die, or just making sure things are titled correctly and beneficiary designations are set up in order to minimize or avoid future estate tax, inheritance tax, capital gains tax, income tax, generation skipping transfer tax. So important to have all of that as part of the planning process, inventory and value. Also, when we have that inventory done, we always want to find out, even though, and you may not know this, even though your will doesn't control who gets your life insurance or your retirement accounts, that's done through beneficiary designation. It's always good to know when you're getting your first will or any will prepared. Let's take a look at that life insurance and at those retirement accounts. Not only where are those accounts held, not only how much life insurance, what's the value of the retirement account, but who are the present designated beneficiaries. So many times that's often overlooked because someone may have purchased a life insurance policy 30 years ago. Someone may have opened a retirement account, a 401k or an IRA 20 years ago. And just as part of the account opening process, they just threw on some names for designated beneficiaries, and that never got revisited, but maybe life circumstances changed. So all that we need to know about in the kind of will preparation process. That's number two, inventorying your assets. Number three, another will writing aspect is identifying who your heirs or beneficiaries are. Of all of the 11 components of this live stream, this one is where the rubber meets the road. This is the who gets your stuff. And you may think it's really simple, but sometimes it needs to get a little more complicated than simple. So many married couples, and I work more often with married couples than with non-married people, but of course we work with both. But it seems like when they get to me, it's a married couple, kind of the typical scenarios, that married couple, they're maybe in their 60s or 50s, mid 60s, and they're serious now. It's time to make sure they get this right. They can't make a mistake. And so this part here is really, really important, identifying your beneficiaries. The reason it's important is because it has to be set up just right. You may write a will when you're 50 and die when you're 95. And that will doesn't go invalid because you lived too long. That will might be in effect for 45 years. You can imagine some life circumstances may change from when you were 50 and wrote your will to when you're 95 and you pass away. So oftentimes in your will, we've got to try to structure it to accommodate for reasonable contingencies and reasonable circumstances that might occur. Yes, you can update your will at any time. A will is always something that you can change. We'll talk about updates later, but just that's the nature of the estate planning process. Some people write wills and they don't die for many decades later. So we got to do it right. All right. So some of the issues surrounding how to identify who gets your stuff. Let me start with some basics. Some first time will writers, they come to me kind of scared because they think it's an overwhelming task. They're like, Paul, boy, you talked about on your video making this inventory of assets. Paul, I got stuff all over the place, and I don't even know if I can think of everything that I have and jot it all down. By the way, going back to that one for a second, just to let you know what we do for our clients, just to kind of let you know what's out there. All of our clients have what's called an online secure portal. It's built for estate planning, and it enables you to put all of the information that someone might need when you pass away in one secure online portal. Doesn't rely on hard copies of paper, but so you'll have all of your family information names in there. You'll have all of your asset information. You can compartmentalize the real estate, the stocks and bonds, the business interests, the retirement accounts, the bank accounts, the vehicles. All of the relevant information is in that secure portal, along with all of the necessary supporting documentation, whether that's wills or trusts or powers of attorney, more on that later, insurance policies, vehicle titles, all that gets uploaded to your secure online portal so that all that information is securely stored in one online place. So that helps with the inventory of assets back to the designating your heirs or beneficiaries. So the simplest for a married couple, whether or not this is right, that remains to be seen. Whether it's right depends on a conversation that we or you and an attorney may guide you through. A real simple one for married couples might say, when I die, I leave everything I own to my spouse. And if my spouse predeceases me, I leave everything to my children. Or maybe it says I leave everything to my children, to my descendants per stirpes. That covers, if a child dies before you and the child had children, then what would have gone to the child would go to the child's children. So that's about as simple as it gets. It's, I never like to see a will that just says I leave everything to my spouse. Because if you have a spouse and your will says you're leaving everything to your spouse, pretty good chance that your spouse may die before you. And then if you don't address what happens if your spouse predeceases you, you're back to the state law, and the state will determine who gets your stuff, assuming that your spouse predeceased you. So there's some heirs that are named in your will. There's some, if these heirs predecease me, I want that to go here or there. Those are some kind of primary issues. Secondary issues when it comes to identifying your heirs are, should you leave things to people outright, or should you leave things to people in trust? And we haven't gotten to trust yet, but we will. Trusts are used for a lot of different reasons. And when I talk about, do I want to leave it to someone in a trust? Sometimes it takes a while for people to kind of grasp this, but you might have a will, and in your will, you say that when you die, assets go to or for certain people in a trust. All of the terms of that trust can be inserted into your will so that those trust provisions that are part of your will, it's called a testamentary trust, a trust, the terms of which are in your last will and testament. And again, since your will doesn't take effect until you die, that trust doesn't take effect until you die. But if you write a will and leave assets to a testamentary trust, all of the terms of that trust are within the confines of that will document. A testamentary trust will probably make your will a little bit longer or a lot longer. Sometimes a will has several testamentary trusts, and that's okay. And sometimes it's necessary and appropriate. So let's talk about when kind of ordinary people would want to include a testamentary trust in their will. First of all, married people write wills with testamentary trusts all the time. So instead of, let's take husband, for example, let's say he has a $3 million estate. Um, he loves the simplicity of I just leave everything to my wife, and she may have assets of her own. She probably does, but she'll keep owning her assets after he dies. But he's also under that scenario. She's also going to get the $3 million estate that he had. Sounds simple enough, and then she'll hopefully leave it to the kids when she dies. And keyword there, hopefully. Some married people in that situation say, if I leave everything to my spouse could live another 10, 20, 30 years. Who knows what kind of mental capacity my surviving spouse might have 30 years after I die. My spouse might get influenced by someone, one signature. My kids are disinherited. I don't want that to happen. I'd like some more protection for my children. So very reasonable for married people to say, and that husband in our $3 million example to say, I leave my estate in trust for my spouse. And so then there's some decisions. Okay, a husband dies, his $3 million estate goes into a trust for the spouse. Some decisions there. Who's going to be the trustee of that trust after the husband dies? Maybe it's his wife. Maybe it's his wife and one of his children as co-trustees. Maybe it's somebody else. But generally that trust might say, when I die, that will might say, when I die, I leave my estate in trust for my spouse. Doesn't have to be, but I name my spouse as the trustee of this trust. My spouse is entitled to all of the income that trust generates after I die, and my spouse can get that income for the rest of her lifetime. Trust might further say that after husband dies, if the trustee, who in our example is the wife, if the trustee determines that the wife needs principal distributions from the trust for her health, education, maintenance, and support is a common term used, then the trustee is entitled to make distributions of trust principal from that trust to that surviving wife for her health, education, maintenance, and support. And then the key provisions here are that testamentary trust that the husband wrote into his will says that I leave my $3 million estate in trust for my wife. My wife's the trustee. My wife's the income beneficiary for life. My wife can take principal distributions for her health, education, maintenance, and support. And when my wife later dies, those trust assets revert to the principal beneficiaries, which are the husband's children. The wife doesn't have the right to designate who gets that principal, that trust principal, when wife dies, because by the husband writing a will and leaving his estate to a testamentary trust for his wife and ultimately his children, he gets to control what happens to those assets when the wife later passes away. The wife doesn't get to leave that to, quite frankly and bluntly, to her next husband or to the postman or to the pool boy or whoever you want to make a joke about. All right. So now there's other reasons people create testamentary trusts and wills. And again, we're on topic number 3 of 11, identifying your heirs and beneficiaries. We talked earlier about how one of the reasons people write wills is for those people who do have minor children, designating the guardians who's going to raise those children if the parents pass away before the children reach the age of majority. And then those parents who do that, who have the young children, they'll not only designate guardians for the minor children, but they'll also designate that if they pass away and the children are still young or minors, what we could define what we mean by young, then when the parents pass away, because the children are young, those assets would go into a testamentary trust for the benefit of the children. And again, you'd name a trustee of that trust to handle the children's inheritance until they were old enough to handle it for themselves, use it for your children's education, living expenses, all that can be defined. That trustee that you name for your minor children, or maybe you're leaving a bequest to your grandchildren, same principles apply. You have grandchildren and you'd like to leave. We had someone this past week. I want to leave $200,000 to each of my grandchildren when I pass away, but it needs to be in a trust for them. My grandchildren are 3, 5, 7, and 8. So when grandpa passes away, $200,000 will be carved out of his estate for each of his 4 grandchildren. He designated trustees to handle that when grandpa passes away, so that that trustee who was going to be the parent of the grandchild, who was also the child of grandpa, if you're with me, then I think we said that course, that trustee has the discretion after grandpa dies to use the grandchild's $200,000 inheritance for the grandchild's health, education, maintenance, and support. And then we set a certain age at which that trustee no longer needs to be the trustee, and then the grandchild, once they're old enough, can handle whatever's left on their own. So lots of other reasons we use testamentary trusts. If you have a child who has special needs, maybe getting certain entitled to certain government benefits, in order to preserve those government benefits, instead of dumping an inheritance into their lap, you leave it perhaps to a special needs trust in order to preserve the government benefits, because they would be kicked off of their government benefits if they received an inheritance in a lump sum. So you leave it in a testamentary trust for them. Again, we're going to talk about other estate planning tools that get used sometimes in place of the traditional will with testamentary trust, but that'll come later. We're just right now, we're talking basics. I don't even have a will type discussion. Okay, so there's a lot involved with the identifying the heirs and beneficiaries of your will. Number one, it's who's going to be those primary beneficiaries, and then and also with that, it's who are those contingent beneficiaries, which would perhaps step into the primary beneficiaries' shoes if the primary beneficiary predeceases the testator. And then number two, should those bequests to spouses, to children, to others, should those bequests be outright so that the recipient can do whatever they want to with all of those assets, including giving them to whoever they want to? Or should those assets that you leave to a spouse or children or others be placed in a trust because you want to put some controls and some checks and balances over how those assets will be used for a period of time after you pass away? So there's a lot involved there. Okay. Next is, after identifying your heirs and beneficiaries, is who's your executor going to be? Really an important decision. I think some people probably don't give that decision the careful thought that it deserves. So because the executor that you name can make or break both your estate, and they can make or break the relationships of the people who are participants in your estate settlement. We've all heard of the estates that, World War VII or whatever it was, and had way too many people talk to me and say, Paul, I'm here because I got to get my estate in order. I'm on this Zoom call because I'm overdue. I'm not getting any younger. I need to get my estate in order. And then I'm like, well, what's the urgency there? Tell me a little bit about what prompted you to get in touch with me and set this up. And they're like, well, my mother died 2 years ago, and my brother was the executor, and boy, he screwed everything up, and I haven't talked to him in a year and a half, and I probably never will talk to him again. So, we hate see those circumstances where someone passing away with assets, where it really should be a scenario where relationships of survivors are enhanced. But unfortunately, in many cases, relationships of survivors get destroyed for any number of reasons. One of the reasons they either get enhanced or destroyed is based on who you choose as your executor. I will tell you, it's very common for a married person to name their spouse as their first executor, and maybe one or more children as the contingent secondary or alternate executors. That's common. Whether that's right or wrong, that's remains to be seen. But let me just, maybe when we talk about choosing the executor, maybe I could tell you what their role is. So for example, the executor's role really gets have a lot more detail when that surviving parent passes away. So let's say dad passed away 5 years ago, mom passed away, and now her executor has to get mom's estate settled. And so, and that executor might be one of mom's children, might be multiple children as co-executors, and might be somebody else. But that executor, in the usual scenario, mom has a home, mom has a car, mom has accounts at various financial institutions, mom has bills, mom has a credit card. And of course, all of the not all of the time, but sometimes at least one of the heirs is like, hey, let's get this thing going. I need the money. Got to go buy a new car. Got to go buy a new truck. Got to pay off some bills. I'm in a jam. And so sometimes there's some stress going on there. And so that executor's job, the functions that they typically perform are gathering all of the assets on all of the information on mom's assets and her debts, hiring the lawyer who guides the family through the estate settlement process, which often moves much slower than people wish or anticipate. So that delay causes stress. You need to have an executor who has good relationships with all of the participants in the estate settlement, has those good communication skills to kind of keep everybody and keep those expectations reasonable. So the executor oftentimes will sell the house, sell mom's house. The executor, once they have the proper appointments from the court, then the executor will open one or more estate accounts at a bank or at a brokerage firm, depending upon what kind of financial accounts mom had. Did she have bank accounts like checking accounts, savings accounts, and CDs? Did mom have brokerage accounts that held stocks, bonds, mutual funds, exchange traded funds? Maybe mom had all of the above. So that executor, once confirmed, because what happens is the executor hires the lawyer, court pleadings are prepared, the will and the court pleadings are filed at a courthouse. A judge has to declare that mom's will is valid. More on validity in a minute, but the executor has no power until the will and the appropriate court pleadings get filed at the courthouse. Typically, a judge reviews the will, makes sure it meets all of the validity requirements. Does it have the wording in there that it needed? Is it signed in the right places? Did the notary and the witnesses, if a notary was required, is all of that done exactly how it's supposed to do? Then if it is, a judge will sign an order that the will is valid, and a judge will sign another order confirming that the executor now has the power to settle mom's estate. And then after getting tax identification numbers for the estate, the executor will likely go open some estate accounts, maybe one, maybe multiple, probably an estate account at a bank, maybe an estate checking account, maybe an estate brokerage account if mom had a brokerage account and assets need to be moved from mom's frozen brokerage account into the estate brokerage account. Those estate accounts are typically temporary accounts that hold funds or hold investments while this process of settling the estate is going on. But at the end of the estate settlement, might be 6 months after mom died, might be 3 years after mom died, then these estate accounts are ultimately closed and the assets are moved out of the temporary estate account into the names of the heirs. So the executor often oversees that, often oversees selling the house. Again, if it's sold from the estate, the check at the closing is payable to estate of mom. Executor goes and deposits that into an estate account. The executor often has to deal with creditors like credit card companies. They have to deal with all kinds of requests from all of the heirs. Hey, I wanted mom's car. Hey, executor, mom told my son that she always wanted her grandson to have the car. Or hey, executor, mom told my daughter she could have her diamond engagement ring. So typically all kinds of requests from heirs, and that executor has to just deal with all of that and really, dot the I's, cross the T's, follow the law, make sure everything goes like it's supposed to go. So everyone names an executor. Sometimes it's a child, an adult child. Sometimes it's two or more. If you're going to name two or more co-executors, you just have to realize they might have to jointly go through more red tape than a solo executor would have to go through. I've dealt with a number of banks that have told me, Paul, we're not going to work with co-executors on an estate. We'll only set up estate accounts when there's one executor. So Paul, there's two executors in this case. There's three executors in this case. The only way we can move assets into an estate account is if there's only one executor, one or two of these executors must resign, and then we can open an estate account. Sounds silly, but it's just the nature of the beast. Every financial institution has its own policies. So we often get the question, Paul, can I name all my children to be the executor? A lot of parents say, they're thinking in the back of their mind, I see those wheels turning. Geez, I don't want to offend, our daughter, she's married to this guy and he's really controlling. And our daughter, she's not very organized and she doesn't balance her checkbook and she's overdrawn her account a few times. But geez, I don't want to offend her by not naming her as a co-executor. So let's add her in there as a co-executor. So too many people make the decision of who to select as an executor based on emotions and about whose feelings are you going to hurt, as opposed to, okay, who's the right person to, after I pass away, to be stable and organized and communicate clearly and continue good relationships with all of the parties that are involved, going to be on top of things, not going to let things drag on for too long. Who's going to be that person that can best do that? So that executor appointment may be one of the most important appointments that you make. And so always wise, because I said earlier that maybe your will be in effect for 30 or 40 years, to name those backups. And a couple of other key points on the executor is probably not a bad idea to address the executor compensation issue. Every state has laws. I'd say in most wills, the issue of executor compensation is not addressed. Fred Flintstone may have a will that says, I name my wife Wilma as my executor. If Wilma predeceases me or she can't do it or refuses to do it, then I name my daughter Pebbles to be the executor. And that's pretty much as far as most wills go in the area of executor compensation. And so since executor compensation wasn't addressed in the will, guess who we turn to? State law to determine what that executor compensation might be. So for example, let's say you have 4 children. You name one of your children, the one that kind of in the back of your mind. They're responsible. They're going to do the job. They're going to get it done. They've been helping you with your bills during your lifetime. You've named them as the executor, but you just don't address the whole executor compensation thing. Well, your state has a statute. Likely it tacks on a percentage of the estate executor compensation. Let's just say your state says 3%. Some have a sliding scale. Hey, on the first $400,000, the executor compensation is 4%. On the next 200,000, it's 3.5%, whatever. Let's just say the executor compensation is 3%. Well, if you have a $3 million estate and the executor gets the statutory compensation, that's $90,000 off the top that your executor gets, and then the heirs split the rest of your estate. Sometimes that causes some friction there among those heirs. Now, you can address it any way you want to. Sometimes people say, I direct that my executor shall not be entitled to compensation except for reimbursement of expenses that they incurred. And quite frankly, even when an executor is entitled to compensation, they often waive it. That child who's the executor, the child is one of 4 children. Mom with the $3 million estate left her estate to the 4 children equally. That child who's the executor is inheriting $750,000, just like their 3 siblings are. And so sometimes that executor says, you know what, I'm not going to accept that executor compensation. I'm honored that mom chose me to be the executor. I'll do it without compensation. All of us will be treated the same, but I'll just do it without compensation. By the way, executor compensation is subject to income tax when the executor does actually get their compensation. So if that daughter received her $90,000 executor compensation, that would be taxable income to the daughter. And so she'd, lose a portion of that to income tax. But the inheritance is not subject to income tax. That's another reason often executors waive their compensation. Hey, let's just receive all of this as an inheritance. An inheritance is income tax free. There won't be any taxable executor compensation. So again, a whole area there on choosing your executor. Let's move on. This one will be quick. It's number 4. It doesn't apply to everyone, but it applies to parents with minor children. Designating guardians for your minor children. Okay, so while it doesn't apply to people who don't have minor children, Now, people might create their will when they're 21 years old and they don't have any children yet. So no harm in designating, if I do have minor children when I pass away, I want so and so to be the guardian of my minor children. No problem there. But we deal with a lot of people in estate planning who are in their 60s or 70s, and they're just not going to have minor children when they pass away. So we can kind of skip this part for those 70-year-olds who aren't going to have any more minor children for sure. But if it does apply, it's one of the most important decisions you can make as a parent of minor children. You might designate the same person as your executor, as the trustee of the testamentary trust for your minor children, and as the guardian for your children to have those kind of parental rights. It might be all the same person. It might be all different people. Some people have said, I want my sister, if I pass away, I want her to be able to raise my kids. I want her to handle my kids' money, and I want her to settle my estate. Other people have said, I want my sister to have those parental rights and be the guardian of my children, but I want my brother to handle the money and be the trustee of these testamentary trusts that we created for our children. And I want this other person to be the executor of my will, that temporary position to make sure that the assets get moved from your estate to those testamentary trusts that you've established in your will. So they can be all the same people. They can be different people. There is no right or wrong here. It's what's right in your circumstances. Okay, moving on. Your debts and your taxes. Okay, another issue about wills is especially, if you have a mortgage and you have debts, like so many people do these days, is dealing with the issue of debts that you have and taxes. And I'll get to taxes in a minute. But a fairly common scenario is people wanting to leave their house to someone specifically. Doesn't happen all the time. Some people with 3 children just say, I leave my estate to my 3 children equally. But sometimes, I wouldn't say it's not a majority of the time, but it has happened many, many times. People say, I want to leave my house, or a married couple may say, we want to leave our house to our daughter. She's never owned a home. She lives in an apartment. She struggles making her ends meet. I feel like if we don't leave her this home, she'll never own a home of her own. So there's some issues with that, especially when it comes to a mortgage. If you're going to leave an asset that is subject to a loan or a mortgage, a homeowner's loan, a car loan, rental property that has a loan, if you're going to designate that to certain people, you need to address, well, what happens to that mortgage when you pass away? So do you want the residuary of your estate to take care of the debt? So maybe you say, I leave my house to my daughter, but if there's a mortgage on it when I die, I want my other assets to be used to pay off that mortgage, and then my daughter can inherit the home free and clear. Or maybe your desire is, I still have $100,000 mortgage on that home, and the home is worth $600,000. So when I pass away, I want to leave that home to my daughter, but it's subject to that mortgage. So if she's going to keep the home, she's going to have to continue making those mortgage payments, and those if it's $100,000 that you owe when you pass away, it's going to be her responsibility. So need to know what those debts are. There's another reason we need to know what the debts are, because that factors into whether there's estate tax or inheritance tax due when you pass away. A few states have an inheritance tax, but we do have a federal estate tax. Now, these are some big numbers. And for people who are writing their first will, when I think of, I don't even have a will, when I think of I'm writing my first will, I'm often thinking about those people who are maybe in their 30s and 40s. They've got some kids they're trying to raise, and they realize how important it is to name guardians and make testamentary trusts. Sure. Have I done a first will for someone who is 70 years old and has an estate worth tens of millions or even hundreds of millions of dollars? Yes. But when I'm thinking first will, it's those people who are 30s, 40s, maybe 50. They don't have the really large estate, because if you have a really large estate, you're likely to have probably done some estate planning in the past. Who knows? But dealing with debts and taxes, might as well go and address it. We do have a federal estate tax. It applies to people. Doesn't matter where you live. And but there's some really big exemptions or exceptions, and very few estates are subject these days to the federal estate tax when somebody dies. And the reason so few are subject to it is that when someone dies, if someone dies in 2024 this year, the first $13.61 million that they have is exempt from the 40% tax. Only the assets that they have in excess of $13.61 million are subject to the 40% tax. And quite frankly, if you have debts, if you have big numbers here, $16 million of assets and $6 million of debts, well, you have a $10 million net estate. And if the exemption is $13.61 million, there's going to be no estate tax due, because the estate tax is applied against your net estate, not your gross estate. And debts are one of those things that get reduced from the gross estate before the net estate is calculated, in addition to bequest to spouse and bequest to charities and other issues that we get into when we talk in more detail about the federal estate tax. So, but again, good to know what someone's debts are when they're going through the planning process. Helps us determine whether how to structure certain bequests, and can tell us whether any kind of special tax planning is required. Oh, by the way, this $13.61 million exemption that people who die in 2024 have, it's going to be cut in half, or scheduled to be cut in half. There's a lot of debates as to whether Congress is going to pass legislation at some point in the next year and a half to keep that exemption at $13.61 million plus, because it gets increased every year for inflation. Or will Congress take no action, let the Tax Cuts and Jobs Act sunset on January 1st, 2026, which is what will happen if Congress takes no action, and that estate tax exemption will be cut in half, probably somewhere around 7 million and some change, based on the inflation adjustment factors that get factored in every year. So yes, I mentioned $13.61 million. Maybe you said, whew, I don't have that. That tax won't apply to me. But then upon you hearing that it may come back to $7 million, maybe you have a $6 million estate now, and in a couple of years, it's probably going to be worth more than $7 million, because you're still earning and your assets are appreciating in value. You may need to take notice and make sure you take the right action. Okay. So in addition with debts, there is a tax component to dealing with all of this. We just talked a little bit about the estate tax. Some states have their own estate tax in addition to the federal tax. Some states have an inheritance tax, not many. But and then there's capital gains tax and income tax consequences. I guess if I'll hit on the maybe two quickie points about writing a will and the capital gains tax and the income tax. First, let me touch on the income tax. Generally speaking, an inheritance is exempt from income tax. If your mother dies and she has a bank account that has $600,000 in it, and she leaves it to her three children, you're one of the three children, and you get $200,000 from her $600,000 bank account when your mother passes away, you don't owe income tax on that $200,000, because generally speaking, an inheritance is exempt from income tax. Again, let me define what I mean by generally speaking. An inheritance is exempt from an income tax. When you inherit from parents, for example, you're probably going to be inheriting maybe a traditional IRA or a traditional 401k. No income tax has been paid on that traditional IRA. Perhaps your parent was taking required minimum distributions every year and paying income tax on those required minimum distributions. Maybe they were taking out more than the required minimum distributions, but they passed away with a balance of $600,000 in their traditional IRA. You're a 1/3 beneficiary along with your two siblings. Now, what will happen is your $200,000 of that $600,000 will be placed into an inherited IRA in your name. And then generally speaking, you have 10 years within which to take money out of that inherited IRA. And when you do take money out of that inherited IRA, you're going to include that as part of your taxable income. So there's just no getting around the income tax that individual beneficiaries must pay when they inherit or are a beneficiary of a traditional IRA or a traditional 401k or a traditional simple IRA. Yes, the Roths, they come out tax-free. That's lovely. That's fantastic. But I'd say there's a lot more traditional IRA money out there than there is Roth IRA money. And so just be aware that's my, generally speaking, an inheritance is free of income tax. I got to mention the generally speaking because the exception is that traditional IRA. But when you inherit a bank account or some shares of stock or even a house, you don't pay income tax. Now, speaking of inheriting stock or a house or land, now we're going to talk about the capital gains tax. So there's a huge tax benefit that comes from inheriting an appreciated asset. And so my son called me today. He lives in Texas, and he was talking a little bit of investing accounts with me. And we started talking about NVIDIA stock, which, by the way, luckily we both own. And their stock has increased tremendously in the last few years. And so let's say, and in fact, I saw an article, a silly article the other day that says back in, I think it was 1999, if you would have bought in $10,000 of NVIDIA stock, it would be worth $59 million today. Yeah, keep dreaming. And boy, just think if you took a flyer on NVIDIA stock back in 1999, you probably wouldn't be listening to this recording, or maybe you would be, but you probably need to. So anyway, when someone dies owning appreciated assets, and in this case, we're using NVIDIA stock that maybe someone did buy for $10,000 and now it's worth $400,000. That's $390,000 of capital gain. They bought the stock for $10,000. Today it's worth $400,000. If that person who bought that stock sells that stock when it's worth $400,000, there's $390,000 of capital gain. That's all capital gain. And that person will have to report that as capital gain and pay capital gains tax at some amount based on what the state and federal levels are based on where you live. But maybe you'll pay 25 or 30% capital gains tax on that $390,000 of gain. And that's, that's a lot of tax. That's six figures of tax from selling some shares of stock. Now, if you don't sell the stock and you pass away, you have to pass away to get the big benefit here. It's a pretty big price to pay, but it's going to happen. If you pass away owning that NVIDIA stock that's worth $400,000 and you leave that to your heirs, well, all of that $390,000 of gain from when you bought it for $10,000 goes untaxed due to the step up in basis rule. All of the assets that are in your estate when you die, they get a new basis when you die. The basis is the value of the asset on the date that you die. So you bought it for $10,000 many years ago. You die, it's worth $400,000. Now your heirs inherit that stock. Their basis is $400,000 or whatever it was worth on the day that you died. So they can sell it immediately and incur no capital gains tax, unless, of course, there was appreciation since you died. They pay tax on that appreciation since you died. So maybe they sold the $400,000 of an NVIDIA stock for $440,000 shortly after you died. Then, well, there's $40,000 of capital gain there that, they pay capital gains tax on that $40,000 of capital gain. So a couple of these tax rules that people who are first-time will writers need to know. All right. So let's keep going here, and then we're going to get to some good chat stuff. All right. Next issue for you first-time will writers, you just absolutely have to follow the legal requirements for writing a will, and there are many. And just a few of them are, yes, it has to have the right language in it that makes it a will. Sometimes I'll see a document, I'm like, is this the person's will, or is this just like vomit on the page? And so, but yes, very particular requirements must be met. They're all state specific. Certain language has to be in there to make it a will. Certain language has to be oftentimes at the end. And if the wording is off just a little, then it's not a valid will. There's notary and witness requirements. There's signature requirements. Some wills have to be signed on each page, some at the end, some once. And so all of that, you need to make sure you follow all of the validity requirements. I think we have about 27 states. People ask me, Paul, can I handwrite a will? And you know what? I think there's about 20 states where those state legislatures or assemblies or whatever you want to call it have actually created legislation that enable people to handwrite their own will, and there's no notary or witness requirement. That's never the concern to me, is did they make it valid by handwriting their own will? The concern with handwritten wills I get all the time is, did it accomplish what you were trying to accomplish? Sometimes one word written the wrong way can really screw things up. I remember years ago, I was dealing with a handwritten will after a mother died of cancer. She knew she was dying. She heard that she could handwrite her own will, and she did. That will, after she died, was brought to me. And I'm reading this handwritten will, and they're like, is it a valid will? And I'm like, yeah, it meets the validity requirements. It's all in her own handwriting. It's dated in the right places. It's signed in the right places. It's a valid will. But the problem is, I don't know what to do with all of mom's stuff, because mom said in her will, she wrote, oh, my mother's still alive and I don't want her to have to go into a nursing home. So I'd like for her to have a place to live as long as she lives. And then her will went on to write, yes, but my husband, I just married him a year ago, and boy, he needs a place to live. So I want to make sure that he doesn't get kicked out of my house. And then she went on to write, I have a 19-year-old daughter who's in college, and I want her to have a place to live. And so all of that is how I'd like to leave my house. And so we had to go to a judge, and the judge was like, geez, and I don't even know whose name this house needs to go into. Big mess, big family fight, didn't get resolved without a lot of expense and a lot of hard feelings. So that's my story on, if you live in one of those 20 whatever states that do permit you to do an holographic will, yes, pretty easy to meet the validity requirements, but not always easy to make sure that you're accomplishing what you're trying to accomplish. Because quite frankly, when you write your will or when you pass away, that's when the will gets scrutinized. And, in our case, lawyers for all three of those parties, the mother, the husband, and the daughter, all had their own interpretation of her will. And the three lawyers had different interpretations. And so that's when things get nuts. It's a valid will. Clearly, the will was valid. So it was easy enough for her to make a valid will, but valid and easy to administer and written clearly and unambiguously, those are two completely different things. All right, so got to make sure everything's legal. All right, we're rolling down here. We're about to go to some chat. I see we got some good chat here. Keep the chat coming. Next is updating your will. I mentioned earlier, sometimes people write their will when they're 50 and they die when they're 90. And quite frankly, it never needed to be updated. Maybe that will said, I leave my estate to my spouse. If my spouse predeceases me, I leave it to my children, or I leave it to my descendants per stirpes, or I leave it to my children. And if my children predecease me, then I leave the child's share to the child's children. And I name my spouse as my executor. I name my daughter as my alternate executor. Will stays in effect for 40 years, never needs to be updated. I think the mistake that some people make is that they think every time they move to a new home, or every time they buy a new car, or every time they change their address, then, got to update the will. And it's just not the case. Your address isn't going to be in your will. Oftentimes, most of the time, the assets that you own are not listed in your will. So if you get rid of everything after writing your will and get new stuff, the will that leaves everything to your children, it doesn't need to be changed. Now, it may need to be changed if you said, I leave the property, or I leave my home at 123 Sesame Street to this person. Most wills don't get that specific. Some do when it's necessary and appropriate. But oftentimes there aren't specific assets listed in a will. So, but if there are, if you leave, I leave ABC Business LLC to Fred, and then after you write your will, ABC Business LLC shuts down and you start a new business and maybe you want that new business to go to Fred. Well, you better update your will because you left Fred ABC Business LLC, and that LLC no longer exists. So to the extent you leave specific items to specific people, that is common if you to update. So, but many wills just isn't necessary. They don't go invalid just because some time has lapsed. However, some people do have changes in circumstances. So some people will have their will when they'll create their first will when they're married and they have children. Children might be young or young adults. And then later in life, they have grandchildren. And they're like, boy, we want to leave something to our grandchildren. So changing your will is appropriate when you want to change who's going to inherit from you, or if you want to change who that executor will be, or if you want to change who those guardians of your minor children will be, but you might kind of outgrow the need for having that. So lots of misconceptions about when people need to update their will. Typically, it's not when you move to another home. I guess in these days with lots of people moving out of state, I think most, if not every state has, if you move from one state to another, most states have laws that say, well, if your will was valid in the state that you lived in when you wrote it, it doesn't become invalid because you moved to another state. It just needed to be valid in the state that you were in when you wrote it. But moving to another state might be just to avoid when you pass away, having to prove to your new state's judge that your old will from another state was valid when you did it in that state, to avoid the red tape and legal gobbledygook that's involved in proving your will was valid in another state. To avoid that, maybe that's enough to write a new will. Often when people move to a state, they sometimes they will want to rewrite their will for that reason, and often maybe they may have even changed their mind about who they want their executor or backup executor be. So sometimes there's, in addition to moving to another state, there's some substantive reasons why they would have wanted to change their will. Okay, so that's the update piece. Major changes in life circumstances. Maybe one of your children passed away and you want to revisit who gets their stuff. Those are difficult issues, but that's certainly a major life circumstance that warrants getting things up to speed. All right, now let's talk about, I think this is number 9 of 11. We've been talking 90 miles an hour about your first will and who needs a will, and when you're doing a will, what you need to address. But a will by itself is really never a kind of a thorough enough estate plan. So every time someone does a will, they virtually always do these powers of attorney. I mentioned a couple of times, a will is only effective when you die. Will has no effect while you're alive. It doesn't matter what it says. You may have written the will when you're 50, you're still alive at 85, but will has no effect when you're 85. It takes effect when you die. So some people think, well, mom wrote a will. She named me the executor. Mom's still alive, but she's lost her marble. She can't sign her name. I'm the executor of my mom's will. I'm going to go to her bank and deal with mom's bills and all that. Not as the executor, you're not. So that will has no effect until you die. Now, so to cover what happens if you're alive, but for whatever reason, injury or illness, you're not able to sign your name and take care of your business. Virtually everyone, when they write their will, that's why we call it a will plan, because having a will by itself is not an estate plan. It's a will. Virtually everybody does these powers of attorney. It's, again, will applies when you die. The powers of attorney is you're alive and you're not able to sell a vehicle that's in your name, sign your tax return, go take a distribution that may be needed from your IRA, deal with life insurance issues. Maybe you're inheriting and you don't have the capacity to deal with inheriting and signing all the court stuff that you need to sign. By designating, by creating and having powers of attorney, you're designating, okay, if I'm not able to do stuff for me during my lifetime, I want this person. And if this person can't do it, I want this other person to do it. You get to choose. And it avoids that court guardianship proceeding, which is necessary if during your lifetime you get to a point where you can't sign your name and your signature is necessary and you don't have a power of attorney. Then your family's going to sue you in a court proceeding. ask a judge to declare you incompetent, ask a judge to appoint someone as your legal guardian. You can avoid all that guardianship stuff by having that power of attorney in place and designating who you'd want to be able to handle your business for you if you weren't able to handle it for yourself. Most married people appoint their spouse first, maybe an adult child as the backup. Similar difficult issues if you appoint 2 or more people having to work together. Some financial institutions just won't honor them, or they'll make life very difficult for you. So just be aware of that. Here's maybe the other tool that I should address in this I don't even have a will conversation, so that you'll know about it going into the let's talk about me creating my first will conversation, is when people set all of this up, people either do it through their will and have a will plan. And here's the deal with the will plan. The will plan is, if you've never done any estate planning before, this is brand new to you, you're thinking will, because that's what you see in the movies. That's what you see on TV. That's the traditional way people put their legal affairs in order. That's the traditional way people designate who inherits from them. So the way the will plan works is you leave everything in your name. You leave your home in your name, your bank accounts, your investment accounts, your stock, your business. You leave that all in your name. You write your will, designate who your executor is and who your heirs are. But when you die, all of your assets are frozen. Now your executor's got to hire lawyers like me. We've got to go through a court proceeding. A judge has to get involved. A judge has to confirm that the will is valid. A judge has to confirm the executor's position. And then a judge's office kind of oversees the settling of everything, and nothing can be transferred to the heirs until all of the appropriate inventories of assets have been submitted at the courthouse. The debts have been paid, and then a judge oversees all of that and ultimately signs court orders ordering that estate assets be transferred to the appropriate heirs. Most people, and that court and attorney involved process that applies when you die with a will and assets in your name is typically called probate. It also applies if you die without a will and there are assets in your name. But when you die intestate without a will and there are assets in your name, then there's still the court process, but then the state determines who inherits. At least with a will, there's still a court process that will take place when you pass away, but you get to determine who inherits your assets at the conclusion of the court process. Sometimes it takes months, sometimes it takes years to go through that court process. So knowing, kind of going into this, I don't even have a will conversation, you need to know that many people take advantage of an alternative way to make things easy for your survivors is they create their revocable living trust. So for example, mom or mom and dad, let's just say mom, for example, she might own a home and have some investments in a brokerage account. She may even have an LLC and other assets. And so she says, you know what? I don't want my survivors to have to go through this court and lawyer involved process when I pass away. I think what I'll do is I'll set up my living trust. And so what's called a living trust gets set up. And in that trust instrument, it states who's the trustee of that trust when mom dies. Mom's in charge of everything while she's alive. She can do whatever she wants to with all of her assets while she's alive. There's no restrictions put on mom. But when mom dies, in that trust, mom designated who's going to be the trustee. The trustee settles mom's estate outside of court involvement. Again, if mom had a will and named an executor, probably the same person as the trustee, but the executor is going to settle mom's estate subject to the court's involvement. So when someone has a living trust and they transfer those, what we call probate assets, I'm not talking about the IRAs and the life insurance would have beneficiaries. I'm talking about oftentimes the house, the brokerage account, the stocks, the LLCs. Transfer those assets during mom's lifetime from mom to mom as trustee of the mom living trust. Then when mom dies, see things that are titled in the name of your trust when you pass away. They don't get frozen. They don't have to get lawyers and courts involved. That successor trustee that you have, maybe mom named her daughter as the trustee to handle mom's trust when mom died. If mom's home was titled in the name of her trust when she died, then the day after mom died, the daughter can stick a for sale sign in mom's yard, sell the house, don't need any judges and lawyers involved. And so that's just the way it is. Things that are in that living trust when you pass away, they don't need that court and attorney involvement. Makes the settling of mom's estate typically quicker and easier than it would be if mom used a will to transfer her assets to her heirs. So just be aware going into this estate planning conversation for the first time, there's a will way to do it that, and again, it's done that way every day. I'm not saying one's better than the other or one's right or wrong or more legal than the other. There's the will way to do it where you leave everything in your name. And then when you pass away, there'll be that court involved process where judges will oversee the settling of your estate and the distribution of assets to your heirs. Or there's the trust way to do it, where you create your trust, title assets into your trust, and then that person that you designated, the successor trustee, can take those trust settlement actions immediately when you die without the court and lawyer involvement. Okay, so be aware those are other tools that you have. A couple more items. Should you seek professional advice? Probably. Yep, even if you're writing your first will. As you might imagine, there are lots of things that can go wrong in this estate planning process, and it's probably one of the most important things that you'll do during your lifetime. And if problems happen, you don't even know about it. You don't know about it until after you pass away, and it's too late to fix it. So because there's the drafting of papers and legal instruments, and these things stay in effect for 20, 30, 40, 50 years sometimes, and because life changes happen, and because there's the possibility that multiple lawyers on behalf of different people may be reviewing all of this stuff when you pass away, and for a lot of different reasons, it's probably wise to seek, lawyer assistance. Probably, yep. Do some people get away with the DIY stuff? I'm sure they do. So, but as hopefully you've kind of realized, there's a lot of moving parts here. A lot of things can go wrong. And like I just said, the problem with the fact that things can go wrong is nobody knows about it until after the person who wrote the will dies, and it's too late to fix. And sometimes relationships get slaughtered at that point. Okay, so now, in addition to getting lawyers to help, sometimes the financial advisor, the life insurance professional can play a role. I love it when financial advisors have clients and that financial advisor, more and more wealth managers and financial advisors of yours these days kind of consider themselves to be the holistic wealth manager. And, the wealth management consists of 8 parts or however many they have as part of their holistic wealth management process. One of those parts, at least as they describe it, often is estate planning. But quite frankly, in their defense, financial advisors are having conversations with their clients typically on a regular basis, at least annually, if not more. Most people meet with a lawyer one time, and it may last an hour. Could be less, could be more. But oftentimes the financial advisor knows their client better than the attorney who's having one meeting with their client knows that client. And so there's a lot of reasons why, something we preach, because we do so many Zoom calls with our clients, we have them all over the country. Love it when the financial advisor, if the client wants it, is a participant in that Zoom meeting, because sometimes they'll remember conversations that they had with their client that may be different than what a client is saying today. And in addition, part of estate planning involves titling financial accounts correctly in order to avoid probate sometimes, naming beneficiaries on IRAs and 401ks and life insurance policies that must be consistent with the estate planning legal documents that the lawyer is customizing for the client. So it helps when that financial advisor participates. We have a program for financial advisors who want to be a participant and actively engaged and get all the benefits of the enhanced relationship and the relationship with the heirs that comes from the financial advisor being part of the estate planning process. Of course, the financial advisor doesn't prepare anything, doesn't prepare documents, doesn't render legal advice, but it helps when they're a part of the process. Again, so having professional help typically helps, as long as that professional help is professional. Okay. And then last, another important piece here often gets overlooked is communicating your wishes. It's a personal decision people make when they create their estate plan. Do I tell my kids what I did? Do I tell them all? Do I just tell the executor what I did? Do I just tell them, hey, on my in my cabinet, on the second cabinet above my computer, there's a portfolio binder with all of the legal documents, or hey, I created a secure portal and I'm going to leave you access my username, or I've given you um, credentials, or I've made you a user in my online estate portal. Do you just tell them that the estate plan exists and they know where to find everything? Or do you share more than that? And when you share more, what is it that you're sharing? Well, you might be sharing with everyone, I appointed this person to be the executor of my will. Not only sharing that, but here's the reason why I appointed this person. Or maybe your estate plan says I left 25% of my estate to my grandchildren and I left 75% to my children. And so here's the reason why I did that. And that way, that communication of not only the what you did, but the why you did it can really eliminate difficulty and strained relationships after you pass away. So up to you how much you communicate, but if you we don't want you to skip the communication part if you intend to communicate and you think that would be something that would be good for your family. All right. And then, of course, store everything safely. I talked about having an online portal, but that's not enough necessarily to just have everything stored electronically. It's great to have everything stored electronically, because I can tell you so many stories about people who didn't have things stored electronically and years passed and the hard copies got lost. We moved. We don't know what happened to it. Yep, we still have the binder that you gave, but the tab where our will was, there's nothing there anymore. We don't know what happened to it. So really important to store things safely, especially if you're relying on your will, because when you die, your original will gets filed at the courthouse. A judge reviews it, and a judge hopefully declares that it's valid. If your original will can't be located when you pass away, you're like, oh, we got a photocopy and we got an electronic copy that we can print off as a PDF, but we don't have the original. We don't have the one where it has the raised notary seal, or obviously this is not an original, it's a photocopy. Well, most states, if not all states, have rules that say if you die and your original will can't be located, then it is presumed that you destroyed your will with an intent to revoke it. And so that creates all kinds of problems. And so there's, in our day of these days of storing documents electronically, estate planning is not in the 21st century yet. So that original hard copy will has to be produced when somebody dies, or there's that presumption that you destroyed it with the intent to revoke it. And then perhaps all kinds of court documents have to be prepared, filed, and arguments need to be made that even though we couldn't find the original will, we want to attempt to overcome this presumption that the testator destroyed it with the intent to revoke it. But the burden is on you to prove that. So it's kind of a bummer that the presumption is that you destroyed it with the intent to revoke it. Okay, all good stuff there. We have been going a mile a minute, and we got some chat here, so good stuff. And thanks for everybody for chiming in on where you're from. We got people all over the place. And Big News Johnson, I told you I wouldn't abandon you. If one has a trust, do they even need a will? The short answer is yes. The long answer is yes. When you have a trust and your trust states who gets your trust stuff when you die, and your trust says who your successor trustee is, and there's things titled in your trust already when you died, then that will may not be necessary. We have, maybe you call it a just in case will. If you have a trust and you die with an asset that's still in your name, let's say you created your trust and then 10 years later you opened up or you bought a rental property, and that rental property was in your name when you die, you kind of forgot, I should have bought it in the name of my trust. And you died with that rental property in your name, then that just in case will, much more commonly referred to as pour over will, is necessary, because when you have a trust, your will is likely to say something like, and this is the effect of your will, if I die and there's still anything in my name, I'm leaving it to my trust. So if you die with a rental property in your name, yep, that probate is necessary for that piece of rental property, and your will gets filed at the courthouse, and a judge signs an order based on the terms of your will that the rental property is to be transferred to your trust. So then your successor trustee can deal with it from your trust. So the goal often in estate planning for people who have a trust is never have to use your will, because there's nothing in your name that's frozen when you die that's got to go through the courts. But we always have that will. Whenever someone creates a trust, they also sign that pour over will that's there just in case it needs to be used to transfer something to your trust when you die. Okay, good question, News. Candy says no spouse, no family, no children, no designator, no life insurance, help. Okay, so may want to have one of those, again, in the description, there's a place for you to fill out a little questionnaire that I created and request a time where we can talk by Zoom. Someone has an irrevocable trust. Do they need a will? Yep. There's a lot of people who have an irrevocable trust, really for the same reason that a person with a revocable trust would need a will. If you happen to pass away and there's still something in your name, you need to have a will to cover what would happen to that asset. Hey, from North Carolina, need your will done. Curious about a trust. Okay, fantastic. So we, towards the end, we covered some trust stuff. Oh, and Candy, you acknowledged it. Thank you so much. LJ, good to see you, LJ. LJ's comes from Blast from the Past, says hit the like button. Couldn't agree with you more. Amy says, what would the wording look like regarding principal and interest? Separate principal from interest, meaning in a will. Thank you. Maybe what you're getting at is, let's say you have a CD that produces interest. And maybe, I think if you're wanting to carve out interest and principal to different people, probably the way to go there is to leave that CD to a trust. And when you leave it to a trust that's part of your will, it's what's called a testamentary trust. Mentioned that earlier. If that CD is in your living trust when you die, then in your living trust, you will leave that CD to a subtrust of that living trust. But essentially what you're doing is, let's say you'd want your interest to go to your brother for the rest of your brother's lifetime. And then when your brother dies, you want that CD to go to your nieces and nephews. So you would leave that CD to a trust. Name your brother as the income beneficiary of that trust. That entitles your brother to get all the interest, or if there's stock, dividends, or income that the trust assets generate, perhaps for the rest of his lifetime, if that's what you designated. And then when your brother dies, the asset reverts back to the principal beneficiaries. Sometimes we say in a trust, often we say in a trust, yeah, I name my brother as the income beneficiary. He's going to get all that interest. And sometimes you might want to say, well, my brother can have distributions of principal, and then you define under what circumstances your brother would, as the income beneficiary, would be entitled to distributions of principal. So mouthful there, Amy. Hope that helped. All right, Sprite. Yeah, Susie, Saturday. Yeah, shows you what kind of life I have. So yeah, I got the itch. I hadn't done this in a while, and I've been busy helping people all over the country. It's been fantastic. So let's see what happens. Let's do something on Saturday. My husband is waiting for an organ transplant. I have a stepdaughter who has refused to be in our life for 12 years. We want to exclude her. So yeah. That's going to require some estate planning. And so you need to talk to somebody like me. You could go and set up a time, or at least inquire, express your interest in the questionnaire that we have. It's in the description of the video. We can chat. And so, yeah, if you're wanting to exclude that stepdaughter or your husband's daughter, and it's likely that, yeah, all that's permissible. It just all needs to be documented as to how you're leaving to the estate, not only who the estate's going to, but sometimes we want to designate who it's not going to. And so all that can be done through the proper help. This is exactly why we won't exclude in the event something happens to both of us, so she doesn't hold up my son from selling the house. Yeah. And so may even want to have things in a trust to make it easier for son to sell the house without having to deal with all the probate stuff through the court that the daughter might insert herself in. So again, more reasons to get all this stuff done. How do you set up a living trust? How much it costs on average? What I would do is I would maybe take a look at our website. Again, the link is in the description of the video. We give some ranges there, but we really can't. We absolutely want you to know to the penny what the expense is before you get started. But everybody's circumstances are unique. So we have that first conversation where we determine, hey, What are you trying to accomplish? And let's figure out the easiest way to get there. And we can let you know before you commit to anything exactly to the penny what those expenses would be. All right. Yeah, we do out-of-state work. Pedal and good. I see that you do out-of-state matters. Fantastic. Beach Girls, Georgia. Nice. Linda Roth is so much more flexible. You're right, Linda. Asking my kids to choose those at work. Yeah. Or so many more options with Roth from an estate planning standpoint. I'll have another live stream about that. But yeah, especially if you want to leave your IRA so that it gets paid out over time to certain people. So much more flexibility with Roths because there's not that income tax component. All right, Corvette Girl, Georgia, born here. Fantastic, Lynn. I find it amazing that this step up exists. Yeah, I've had people tell me they like, really? You mean the IRS is going to let all that appreciation go 100% untaxed? And I'm like, yeah. And one or two people in my career, I kind of had to prove it to them. So Section 1014 of the Internal Revenue Code is our step up. I actually, memorized that one and the exact provision just to have it in my back pocket in case someone happened to say, prove it to me. Section 1014. You probably Google it. Williams, my deceased aunt had a will. She lived in Texas. I am the executor and beneficiary, but she left 2 pieces of furniture to a best friend. It's necessary for me to go through probate. Okay. So, some people kind of get around the probate. It's kind of a hack. She left 2 pieces of furniture to her best friend. So furniture typically is not titled. If she left 2 shares of NVIDIA stock to her best friend, yeah, there'd be a probate because stock is titled and we need a court order to order that the NVIDIA stock, 2 shares of it, be transferred to best friend. But you know what? Furniture, if that's the only issue that you're dealing with, then you physically give the 2 pieces of furniture to the friend. Maybe you have her acknowledge, sign something that she's acknowledging that she received her 2 pieces of furniture. And if you are the executor and the beneficiary, and either because of POD, payable on death, transfer on death, beneficiary designations, you're able to get access to everything else. I could see Williams not having a probate unless there was something that was frozen that you were entitled to, and you just have to go through the probate to get the appropriate court orders to get that stuff transferred to you. I have a live video of my godmother in Austin, Texas, wanting me to have everything. Should I pay a lawyer or should I use the video? Well, my guess is, how much legal effect that video will have. So your godmother may have put herself on video. But in order for someone's assets to be transferred to another when they die, it has to be in the proper legal form. In no state is somebody making a video, grabbing their phone and let me make a video. Hey, I'd like to leave my estate to, who is it? Janet. It doesn't meet the requirements of a valid will or a valid trust, and maybe she was standing next to the Pope when she made her video and the Pope was shaking his head. Yeah, I'm acknowledging that's what she did. Doesn't have any effect. So you need to follow the proper form there. So I was a little extreme in my example, but video, maybe one day it'll have some effect, but it doesn't now. We've got, in some states, have some crazy rules about video, but it's not the pull my phone out and make a video kind of video. It's done with notaries and with all these other requirements that nobody can meet. And so anyway, I think that's enough there on that. Hello, Domingo. That's still very informative information on when retitling a bank account to the living trust. Banks are not cooperating and refuse to follow through. In my case, the bank closed the account. So maybe they closed the account and wanted to open another account in the name of your trust. Every bank is different. I've dealt with so many banks. Some banks will let you keep your account number and just retitle it from your name to your trust. Sounds like you've got a bank that they want to force you to close the existing account and open a new trust account with a different account number, which messes everything up due to your automatic bank drafts and all that. So there's a lot of hacks out there that some people take advantage of, naming the trust as your POD beneficiary when you die. So when you die, then outside of probate, your bank account, which is in your name when you die, is payable on death to your trust. That could work. I know a lot of people out there add people as having signature authority on their account so it doesn't get frozen when they die. I'm not advocating that, but that's just a hack that some people do. Susie, good to see you from Illinois. I'd say with the thumbs up, fantastic. So remember that name, Susie. Hey, good to see you, Susie. Janet, the videos, there you go. Okay, thanks for the backup there, Susie. Janet, yes, that is what my attorney told me. If you really said he would take the case for an amount of money because my godmother said she'd die in her home, but that didn't happen. Okay, so yeah, there's a backstory there. Did we just lose audio? I hope not. They placing her in a nursing home. She, anyway, they come very, very clear because more on Janet. All right, so yeah, there's a lot there with Janet. And so good. And Williams, Sheila, you're welcome. Whew. So before you get off, make sure you hit the old subscribe button. Make sure you like. You've been with me now for, geez, and some of you probably been with me for an hour and a half. I got a whole bunch of live streams coming up. I've got a bunch of collaborations. I've been talking to people around the country. A lot of good stuff coming up, some state-specific stuff from a bunch of different states. Got a bunch of lawyers, people in the wealth management business going to join me on some videos. So stay tuned. Check my channel every now and then. We'll see you next time. Y'all have a great evening.